Friends, my today's video is on substantial question of law. Whensoever we file SLP in the Supreme Court, it is based on substantial question of law. Now the first question is substantial question of law. It contains two parts. Firstly, it should be question of law. Secondly, it should be substantial one. So let us go first into question of law. When there is misconception of a document or wrong application of the principles of the law in construing a document, it gives rise to a question of law. So friends, when there is question of law, now let us know how to decide it is substantial question of law. The High Court should be satisfied that case involves a substantial question of law and not a mere question of law. A question of law having a material bearing on the decision of the case, that is a question, answer to which affects the rights of the party to the suit, will be a substantial question of law. If it is not covered by any specific provisions of law or settled legal principles emerging from the binding precedents and involves a debatable legal issue, then it is substantial question of law. A substantial question of law will also arise in a contrary situation where the legal position is clear, either on account of provisions of law or binding precedents, but the court below had decided the matter either ignoring or acting contrary to such legal principles, then it is substantial question of law. But in the second type of case, the substantial question of law arises not because the law is still debatable, but because the decision rendered on the material question violates the settled principle of law. Friends, the general rule is that High Court will not interfere with the findings of facts arrived at by below courts, but it is not an absolute rule. Some of the well-recognized exceptions are where the court below have ignored material evidence or acted on no evidence. Second, the courts have drawn wrong inference from proved facts by applying the law erroneously, or the courts have wrongly cast the burden of proof. When the court refers to decision based on no evidence, it not only refers to cases where there is total dearth of evidence, but also refers to any case where the evidence taken as a whole is not reasonably capable of supporting the finding. So friends, these are the issues, factors, principles by which you can decide whether it is substantial question of law or a simple question of law. For more details, you can go into the judgment, that is Chandrabhan versus Saraswati 2022 SCC online SC 1273. This was decided on 22nd of September 2022. That's all. God bless you all. See you again.